Appeal in for the 5th District of the State of Florida is now in session. The Honorable Brian D. Lambert, Judge presiding. All persons have business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right. Good morning again. As Marshall indicated, I'm Judge Lambert. I'll be presiding over the 11 o'clock case on our oral argument document for Tuesday, May 5, 2026. Again, I'll reintroduce the panel. To my right, your left is Judge Scott Makar. My left, your right is Judge John McIver. Last case is 25-1050, Amelia Island Sanctuary Property Owners Association, Inc. v. Nassau County, Florida, Riverstone Properties, LLC, and I guess the Citizens Against Runaway Development, Inc. Each side has 20 minutes. Appellant, you have rebuttal time. We typically reserve 5 minutes. If you would like something different, let me know, and I'll have the marshal adjust the clock accordingly. And when you get in rebuttal time, the yellow light will start flashing to put you on notice. So if everybody's ready to proceed, let's go. Counsel?
Yes, sir.
Yes, sir. You may proceed.
Everybody's a lot taller than me, so I'm going to pull it way down. Sorry. Good morning to you all.
Morning.
And may it please the court. My name is Buddy Jacobs. I'm here on behalf of the appellant, and I'll go ahead and get started now. I would like the 5 minutes for rebuttal too, please, and thank you very much for that. In this particular case, it involves a settlement, really, that occurred between Nassau County and Riverstone, and they were involved in litigation against each other over a particular height of condominiums on their property. Riverstone owns about 49 acres of property on the south end of Amelia Island. It's between the state park, which has been there since 1988. I know that because I got it bought. And then and next to that is the sanctuary, who are the appellants. And in that case that they had against each other, Riverstone sued the county because they wanted them to reduce the height. To keep the height of their condominiums that they had planned were supposed to be 85 feet, but the county had reduced that area to 45 feet. And so they were very upset about it, and they sued Nassau County. They were seeking $27 million against the county to say that was not a good thing for them. So they went into negotiation and negotiated a settlement. They call it the settlement agreement. We call it different than that, but that's what they call it. And this is what this case is all about before you, is a summary judgment was entered by a judge, and in that summary judgment, she held that agreement was a summary agreement, and we took the position that is really a permitting process that is not an agreement, but a development order. So that's kind of where we are. And what happened in that hearing that they had, the judge ruled that there were no material facts of any kind whatsoever against them for their settlement agreement, even though our particular side had taken the position that there were many of them that were disputed. And in summary judgments, as you know, summary judgments, you can't have anything that is disputed. Otherwise, it can't be a summary judgment.
That may be a little bit of an overly broad statement. You can't have any material factual questions that are disputed. You can certainly have legal questions, and the judge decides those legal questions, of course. Are you suggesting that whether this fell within the legal definition of a development order or not is a factual rather than a legal question?
Well, they had sued, Your Honor, they had sued under the Burt Harris Act, which is Chapter 70 of the Florida statute.
Right. So
And
whether it's
so-
a settlement or whether it is a development order, seems to me that both of those are legal terms, and whether something falls within that legal term seems to me to be a legal question rather than a factual question.
But what they did in that settlement agreement was they didn't complete it under the Burt Harris Act. Under the Burt Harris Act, you are supposed to have, after you set up an agreement, you're supposed to have a case filed or that agreement filed before a circuit judge, and they decide whether or not it has public interest or doesn't have public interest, or whether or not it's substantial to the public.
Is that for all settlement agreements under the Burt Harris Act?
It's for those that are agreed to that have a potential of having something that the public should be interested in. And what I'd submit to you is that in this agreement-
Isn't it only the ones where you may set aside a statute
Sir, I
that have to go
couldn't hear
before a
you.
circuit court?
I'm sorry, I couldn't hear you.
Isn't it only the agreements that may abrogate a statute that have to go before a circuit court?
Well, if you make an agreement under the Burt Harris Act, and it should go in front of a judge if it has something to it that the public would be interested in. And this had a lot
If
in
it abrogates a statute. If it doesn't abrogate any statute, if the agreement does not change any statutory law, if you don't set aside any statute, then it doesn't have to go before a circuit court, does it?
Well, they changed a lot of the comprehensive plan of Nassau County.
Is the comprehensive plan a statute?
Well, it certainly had applicable efforts that would affect the public in Nassau County.
That's an answer to a question, but it's not an answer to the question, was it a statute?
Well, the statute about it would be that under Chapter 163 and also under Chapter 308 of Florida statutes, those had bearings on what was going on there because it affected the comprehensive plan. They had 49 acres, but their plan was they gave 8 of those acres to Nassau County. They also, when they did that, they still got the county to give them 150 units. You're not supposed to get 150 units under the county comprehensive plan if you have 50 units, you can get 150 units, but they were down to 41 units.
Sounds to me like you're arguing against the comp plan amendment. The question, though, was what statute is being abrogated by this settlement that it would have to go before a circuit court for a decision?
Well, I would submit to you that if it was effectuating somehow the public, it should go to a circuit judge, and it did not do that. Also,
Are you making that as a normative argument, or is that what the statute actually requires?
Sir, I'm sorry, I'm having trouble
Are
hearing.
you making that as a normative argument when you say it should go before a circuit court, or are you saying that's what the statute actually requires? Because I don't think that's what it says.
I think it requires it because it does affect the public, and so I think it does require that. That's my opinion. But I would submit to you that they did a lot of things, they changed a lot of things whenever they went forward in doing this. They had, they got the county to agree to 150 units, and they only had 41 acres. So that's far beyond what that should be allowed. They also gave eight acres to the county for beach access to the ocean, and whenever they did that, they did a lot of things that would affect the public. So I would submit to you that it should have gone to a judge for that to be considered. Excuse me, I'm going to change my glasses so I can see something in writing here. Whenever they did this, they did a lot of other things. They had a problem against the county because they wanted to have 85 feet for their height, and the county had changed it to 45 feet. So they had that, that was their main concern about it. But then when they finally settled the agreement, they had a lot of other things in there, a lot of other things that, in other words, their appropriate relief would have been to get the 85 feet over the 45 acres, but they got other things too. They also got the county to remove its power to later alter building height instructions. They also got, the Riverstone was granted permission to measure building height from the graded finish resolution rather than the average neutral grade. The county eliminated its power to alter how building height is measured. Riverstone was granted immunity in perpetuity from any future amendments to the comprehensive plan that alters tree protection and replacement. They also were granted and deemed to have met all obligations concerning provision of parks and recreational facilities. Riverstone is not required to donate the 8 acres for beach access until permitting for future land development.
Well, Mr. Jacobs, do you know for Sanctuary Lane, which is right next door there? Sanctuary
sorry
Lane.
if I'm having trouble
You're familiar
hearing
with
you.
Sanctuary Lane?
Sorry, what?
Sanctuary Lane, which is the road right near on the north edge of the property. There's homes on Sanctuary Lane, correct?
The Sanctuary land it's full of homes, yes, sir.
Right. And what are the heights? What's the maximum height
They're-
on Sanctuary Lane?
They generally go 2.5 levels. They're not anything near. The other thing was 85 feet, which is a whole lot less.
I guess what I get, your client is concerned about the height, number one.
Yes, sir.
What about the number of units
The number of units in that
in the settlement? I mean, the settlement agreement, not in Sanctuary Lane, but the number of
Yeah.
units in the settlement agreement.
the number of units are going to be
150,
150.
Right.
150. But they weren't entitled to that because they only had 41 acres instead of 50 acres, so they weren't entitled to that. And other things that they allowed them to have is that they were permission to build at least 4 lighted billboards on the First Coast Highway. There were no other signs out there more than 6 feet. Riverstone was granted the right in perpetuity to construct cabanas and clubhouses with full food service. Riverstone was granted a right to perpetuity to construct parking garages, tennis courts, pools, bathhouses, playgrounds, meeting facilities, and other structures. Riverstone was granted permission to build within 20 feet of the coastal construction line. In other words, they could change the line from the comprehensive plan. None of the county officers, employees, or agent shall in any way obstruct the efforts of Riverstone to develop the property. So in other words, and that would be in perpetuity. They also were given a buffer of only 25 feet on the northern boundary of the property with no trees, vegetation, or landscaping added, which was deemed sufficient in perpetuity. Maximum yard requirements are reduced, and the power of the county to alter yard requirements was removed. Minimum road frontage was deemed sufficient, and the power of the county to later alter minimum road frontage requirements were removed. All those things were done, which would all against the comprehensive plan for the county. Those were changes done that were things that were not should be taken in the summary judgment, because those were issues that should have been determined, could have been argued, and should have gone forward. So I would submit to you
Are those things specifically enumerated in the comprehensive plan, or are they in local ordinance?
Sir, I'm having.
The provisions that you are suggesting are being abrogated, they are in the comprehensive plan, or they are in local ordinance?
They're in the comprehensive plan of the county. In other words, you move the different directions, different distances. When you put the house down, your maintenance of your house, and you get all these different changes of where it can be, how far is it going to be from the front, the back, the side.
Your main contention about building heights, where is the building height restriction contained?
The building height restriction was just given to them in their argument, but the county had passed an ordinance.
Where is the regulation of building heights Is it in the comprehensive plan, or is it in a local ordinance?
It's in the comprehensive plan. But it was in this plan it went up to 85 feet. Well, it had never been that. And now it's down to 45 feet. So that's what the county.
My understanding, and I might be wrong, is that building height requirements are in the land development code, not in the comprehensive plan.
Well, sir, it's my understanding that it's in the overall plan, but it's probably in the building code as well. All right. Any more questions? That's all I have, and I'd reserve the right in 5 minutes. Okay.
6:23 here, you're very well.
Thank you.
6:21.
Oh, I did actually have one more question.
Mr. Jacobs? Judge McIver has another question.
Oh, I'm sorry.
And as best you can, what actual development did the settlement authorize?
It authorized
Did
them.
the settlement itself actually authorize any development to happen?
It could develop up to 50 houses, 50 units there.
It set parameters for some future development, but it didn't actually authorize any development itself, did it?
Those could not be changed by anything that happened.
Did it?
So they're permanent.
Did it do anything to authorize a particular development, or did it simply set the parameters for a future development?
What they said, everything that I read to you and what it all says, I used the word perpetuity.
Mm-hmm.
So whatever they did, and it also, as I said to you as well, that
Could someone go out?
the
and
local,
Could
the
someone go
county-
out? Could someone go out and start building today, based solely on the settlement agreement itself? Or does there have to be another step?
There would have to be another step, yes, sir.
Okay.
But
A development order?
development order, that could be a development order because it had restrictions on it that would outline what the
A development order actually has to authorize development, right?
it does authorize all those things in the development. So everything that I read to you,
All those things except for the development itself.
well, sir, whenever you're going to do the development itself, you have to go to the ARB board of the homeowner association. You have to do all these different things to get it done. But these are the parameters within which you will build it. And those were restrictions that and as I said to you, and it's in our brief, and it's in their what they call their settlement. All those things are parameters about which that property would be built. So they are very, very much a part of it, and you just have to put something in between it. But you do have the right to move forward to develop it under any circumstance based upon this development or agreement they have with each other.
Thank you, Mr. Jacobs. You got 350 in rebuttal left.
I got 350 left.
Yep, just under 4 minutes for rebuttal.
All right, thank you.
Yes, sir.
Appreciate it.
We have two co-appellees, and we'd like to split the time, please.
Okay, very well.
May it please the court, my name is Jay Bartlett. I represent Nassau County, one of the co-appellees. I think the court is already well on its way to understanding what the issues are here, but I'd like to point out that, first of all, this was a consistency challenge under 163-3215. The relief that Mr. Jacobs described is not available under 163-3215. You either find it's consistent with the comp plan or it's not inconsistent with the comp plan. This is a settlement agreement of a Burt Harris case.
And you only do that if it's a development order.
Exactly, and obviously the court below found very clearly and appropriately that it wasn't a development order, that it did not authorize any type of development property, you have to go through a litany of analysis in order to get to what a development order is, but it pretty much says exactly what you said, Judge McIver. It says you got to authorize development. And this isn't a complicated settlement agreement. It's relatively brief, 5-6 pages. It does a couple of things. The parties give and take. They got their height limitation removed. The county gets excess buffer, especially on the western side of the property, and a nature preserve or conservation easement basically along the highway frontage, which is very important to the amenities of Amelia Island. There's a few other things, but most of the provisions have to do with if development occurs in the future. Okay, so almost everything he described, first of all, is not in the comprehensive plan, but second of all, is not even relevant as of today, because if and when this property develops is an unknown. It's in its natural state right now. The county is unaware of any plans to develop it. The county is aware that there has been interest by preservation groups, both public and private, to keep the land exactly as it is. So most of the agreement dealing with what happens if development ever comes and when there is an application for development to the county, most of the agreement deals with those issues to maintain a certain standard of development for the beach park, beach access that won't hurt Riverstone's property.
Well, counsel, if I could ask you a question on the statute. We all know that the 70.001 subsection C, D1 is the one you're operating under. That's the one that allows for settlement in Burt Harris.
Yes, Your Honor.
And D2 is the one that was discussed earlier. D2 requires a jointly filed action in the circuit court. And that's when there's a statute involved. And let's just assume there's not a statute here. So we have to go back to D1. Now, D1 doesn't say there has to be a circuit court proceeding, but it doesn't say that there can't be judicial review of the parameters in that paragraph, correct?
It doesn't reference any court action whatsoever.
It doesn't say it has to happen.
Doesn't have to happen, that's correct.
But couldn't it well be that under that section that the legislature envisioned that there could be judicial review? In other words, if you have a settlement agreement that has the effect of modifying rule, regulation, so on, the relief granted shall protect the public interest served by the regulation issue and the appropriate relief necessary to prevent the government regulatory effort from inordinately burdening the real property. Isn't that subject to judicial review of whether the settlement agreement itself is in the public interest and whether whether it's gone beyond the Burt Harris limitation or not?
I don't believe that any court has jurisdiction pursuant to that paragraph. There is a case out there.
What's your authority? What's your authority for that statement?
I don't see there any granting a court jurisdiction under that paragraph.
But the statutes are full of thousands of statutes in which courts review whether it's in the public interest or interest. It doesn't have to say the court can do it, but if someone comes in and says this settlement agreement violates the public interest, the public interest must be established here. It's presumptively. I get there's a presumption in favor of being in the public interest. But why can't someone come in and say, Your Honors, this settlement agreement does not serve the public interest, and it goes much further than the Burt Harris Act would allow?
I believe there is a path. I don't believe it's under that particular paragraph. I'm not saying there isn't a remedy, but it's certainly not 163.3250.
No, I'm talking about 70.001.
Right, and I understand. Mm-hmm. There's a Homestead case out there, Homestead versus United States, that lays out, first of all, points out that this settlement agreement is a legislative act. And second of all, it says, here's how you challenge a legislative act. And it sets forth the procedure.
Certiorari? Would it be by certiorari, or what's the?
Yes, it's It's a case for declaratory or injunctive relief.
Okay.
So, I mean, there is a path, but it's not here. It's
Okay.
not in
They,
this
they haven't
case.
taken it. There's no pending action in circuit court seeking a
correct.
declaration or any kind of certiorari action or, yeah.
That's correct. This is what they did instead. They sued under this statute. And as the court below rightly found, this does not authorize development of any sort. It fails to meet the statutory definition of development. It is simply a legislative act, and under Homestead can be reviewed as a legislative act, but it's not what they.
Right. I mean, as we sit here today, we don't know whether there's going to be 150 individual units or there's going to be multiple condominium units with 5, 6, 7 floors or whatever. We just don't know.
We don't know. We don't know, and this agreement does not advance that question any further than that.
I mean, the settlement agreement conflicts with the code height requirement. In other words, it's still 45 feet, isn't it, generally speaking?
It varies by zoning district.
Right.
So it had been 85 before the county reduced it. In that zoning district, that was consistent with that entire zoning district. That zoning district includes many built-out condo properties which are multi-story and are 80 feet, 85 feet.
The sanctuary lane I referred to earlier, is that your understanding too, that most of those homes, if not all the homes, are in the 45, 50-foot range versus 85-foot, or can you not say?
My understanding, I never,
Oh, no.
I haven't seen any data to support my understanding. So that, I'd like to remind the court that there are 2 final summary judgments in this case, one on behalf of the county and the other on behalf of Riverstone, who will speak here in a moment. There are 2 separate theories. Oh, by the way, we adopted each other's summary judgment motions prior to hearing. And so there are 2 separate bases upon which this court should affirm the lower court. One is my argument, which is it's not a development order. The other is Riverstone's, and I'll let them get into it. It really has to do with the interplay between the Burt-Harris Act and this settlement. Again, remind the court that this is a consistency challenge. There was a path for review. This is not it. And because it's not it, we'd ask this court to affirm. Thank you.
Were there public hearings on the settlement agreement, I assume?
Yes.
So the public could come in and say whatever they want to say about it?
Yes, sir. And that is documented in the record. I can't give you a cite, but
Okay. But it didn't form a part of what the trial judge ruled? In other words, if that evidence of the public hearings was put into the record?
it's in the record. I don't believe that it made it into the final judgment, but I know I was at the hearings, and I'm positive it was argued at the time.
Okay. Thank you.
Counsel, you're into your co-appellees.
I'm sorry?
You took 3 seconds of her time.
I took it by asking the question.
We'll give her extra 3 seconds. Judge Makar.
May it please the court.
Yes, ma'am, make sure you speak up so we can hear you.
Christy Russell on behalf of Appellee Riverstone Properties LLC, which respectfully requests the court affirm both of the trial judges' very thorough and well-reasoned orders. Riverstone's owned the property at issue for more than 25 years, and its defense of its private property rights began 5 years ago. After 2 years of litigation with the county, Riverstone and the county entered into the settlement agreement. And as with any settlement agreement, each side negotiated protections for itself. Just reviewing the settlement agreement, it's very clear that each side gave something. So in Section 2, which is the first substantive portion of the settlement agreement, the county restored the 85-foot height limitation on Riverstone, maximum height limitation on Riverstone's property. That is set forth solely in the Land Development Code. It is not in the comprehensive plan. And the whereas clause, actually, it's on the first page of the settlement.
So just quickly, a little bit more broadly, Growth Management Act aside, does the settlement agreement abrogate or modify any Florida state statutes?
No, Your Honor, it does not.
Okay. So dealing then just with the Growth Management Act, the provisions that are modified and set aside, we know building height is not. Is there anything in the agreement that substantially affects your comprehensive plan, or that modifies something that is within your comprehensive plan?
There's nothing in the agreement that modifies the comprehensive plan, Your Honor, no. There are certain provisions, and these are in sections 6 through 9, that comprehensive plans are not something that can be applied retroactively. And so there are certain provisions that were negotiated so that Riverstone would be able to develop the property multifamily. By restoring the height limitation, in connection with restoring the height limitation, Riverstone also did certain things that the county wanted. It agreed to 2 buffer zones. I think one on the northern boundary on the bordering the appellant's property, which in part I think is intended to be more of a buffer with respect to the neighboring community.
And then in the agreement said you can't come back later and change the comp plan to make the buffer bigger.
That's correct, Your Honor. So there are certain provisions in sections 6 through 9 that basically say Riverstone gets to keep the benefit of the bargain because Riverstone's recording a conservation easement and it's deeding away 8 acres of property.
But you haven't modified your comprehensive plan without going through the Growth Management Act procedures.
We have not. There is no agreement to modify the comprehensive plan. Now, with respect to the Burt Harris Act itself, the restoration was with respect to the height limitation, which is in the LDC. And so there was no amendment to the comprehensive plan necessary in connection with the ordinances, and there was no amendment to the comprehensive plan necessary with respect to the settlement agreement.
So then circuit court approval is not required for the agreement?
It's not required for the agreement, Your Honor. With respect to the Burt Harris Act itself.
Well, counsel, if I could get in on that action, because I don't read the statute that way. I see the statute says under D2 that it's mandatory you go to court, and it's mandatory that you go through that process. But just like innumerable statutes out there, D1 basically says you can have a settlement agreement. I think this is the provision that y'all operated under, and it's cited in the settlement agreement, D1, I believe, because the settlement agreement has the effect of modifying the height in the code. Goes to 85. So therefore, the relief granted shall protect the public interest served by the regulations at issue, and goes on to talk about the inordinate burdening of the property. So I don't understand why that is a non-justiciable standard as set forth in that statute. If someone wants to come in and challenge the settlement agreement, and they have standing to do so, they're affected, the property owners next door, why can't they come in and challenge this Burt Harris property settlement under D1 in a court and say, yes, it's presumed in the public interest, but Your Honor, here's why it's not in the public interest, or here's why it's too much relief granted.
Okay, so if I may go back to subsection C before I respond directly to that question, Your Honor. So subsection C gives the local government a whole array of tools to negotiate.
I got it.
And I think everybody agrees that restoring the height limitation, that the local government in this particular instance is within the parameters of subsection C. And so then if we
But
go...
that doesn't make it necessarily in the public interest. It means these are things they can take into account.
Well, this...
Well, what if they said, okay, the height limit is, we're going to waive the 45, it can be 150 feet? or there's something that has changed in the settlement agreement under the Burt Harris Act, why can't someone go to court and say, under D1, this is not in the public interest, or this is too broad to satisfy the act?
Your Honor, that's not the relief that the legislature has provided for. So with respect to settlement agreements under D1, the legislature has added language.
So your position on D1 is a local government can enter into a settlement agreement no matter how egregious, no matter how many provisions of their code can be waived, and no one can complain about it because it's presumptively the public interest and can't litigate it.
If the local government is within the parameters of subsection C, then the settlement agreement is presumed to protect the public interest.
But that's a presumption. But because it's a presumption, doesn't that suggest to you that it can be burst? The presumption can be overcome by evidence in a court?
Your Honor, I think it would be governed, as counsel for my co-appellee mentioned, I think that would be governed by City of Homestead versus the United States, where the court looked at a Burt Harris settlement agreement and said that's a legislative act, and that's what happened here. There was a public hearing. That's a legislative act, and so the only way to possibly challenge that would be if it were arbitrary and capricious. The scenario Your Honor is presenting, I think, potentially would be arbitrary and capricious.
Legislative acts can be challenged in court, too. It doesn't immunize it because it's a legislative act.
No, it doesn't immunize it, but that's not the claim that's at issue here, Your Honor. The only claim at issue was brought pursuant to 163-3215, the only one left. That was the only claim that the trial court was ruling on. And the trial court ruled on two grounds. She said, one, this is not a development order. It doesn't authorize any development.
Okay, so your answer to my question would be, what you're talking about, Judge Makar, that's not this case.
That's part of my answer, Your Honor, is that the court doesn't need to get there because this is a claim under 163-3215. So the first question is this isn't even a development order. But I think the trial court can affirm on both grounds because I think the trial court correctly determined that this is not challengeable in court because there's no ground under the statute itself. The statutory framework is very comprehensive.
Well, now you're saying that 70.01 is in play. I thought I just asked the question.
I'm sorry, Your Honor. The trial court entered judgment as a matter of law on two grounds. The first was that the settlement agreement is not a development order. The only claim at issue is under 163-3215. The second issue is that you can't challenge. She determined you cannot challenge a Burt Harris settlement agreement under 163-3215 because the Burt Harris statute itself sets forth a comprehensive framework for settlement agreements.
Okay, well,
and it does provide for court review.
And that's a different question.
I'm sorry,
She said
Your
you
Honor.
can't resolve Burt Harris under 163, but my line of question has been, can't you resolve a Burt Harris settlement agreement issue, a dispute about it, under the Burt Harris Act itself, under...
If you're contravening a state statute, yes.
Well, that's D too.
But I would say, Your Honor, respectfully, the legislature hasn't provided for anything beyond that, and I think that's because local governments are considering whether they should modify their own local criteria all the time, and they have to engage in these public...
But where is the legal authority for that?
Well, I would
It
say...
said in here that this no settlement agreement can be challenged in court under this provision.
It's in the statute itself, Your Honor, because that challenge provision is only in D2, it's not in D1.
It's the mandatory one.
I don't see any reference to it all in D1, Your Honor. I don't see any reference to a court being
But you
able
understand there's statutes, you've dealt with thousands of them in your life, that doesn't say a court has jurisdiction to challenge the reasonableness of the action. You go to court and you sue, and
There's a statutory construction principle that's eluding me, Your Honor, in Latin, but I believe if the legislature implies it in or references it in one provision and does not reference it in the other,
Right, so it's not
then
so it's not mandatory in D2, but it could be permissible under D1.
I'm sorry, Your Honor, would you...
The language they used made it mandatory under D2, right? You have to go to court. You can't get a review. I mean, the settlement agreement has to be reviewed in court.
That's correct, Your Honor.
But it doesn't say that in D1.
It doesn't mention...
So it doesn't say it has to be, but it doesn't say it can't be.
Well, I think here, it doesn't say it can't be. I think, Your Honor, if the legislature were going to require or imply, here's what it would be doing. It would be implying a private right of action by a non-party to the settlement agreement to essentially void the settlement agreement after the parties have entered into it, after the local government and the private property owner. So anybody can come in and challenge that
Yeah?
when the local government has...
What's wrong with that?
Well, I think you're talking about a legislative act, and so the legislature hasn't implied or provided for that kind of cause of action under subsection D1. You would be left with the United States versus Homestead, which would be, it's a legislative action, so you're under the fairly debatable rational basis standard. And I see that my time has expired.
One more time since I used it up.
You need any more time? We'll give Mr. Jacobs a similar amount of time.
Yeah.
Unless there are any other questions for the court, Your Honor, we believe the court properly resolved this case on both grounds, but the court need not even reach the trial court's determination on Burt Harris. It can certainly affirm on the basis that this was not a development order under 163-3215.
Thank you, counsel. All right, Mr. Jacobs, looks like you have 3 minutes and 50 seconds of rebuttal time.
I'm going to kind of jump in there, Mr. Jacobs. So is there any reason in your mind that the legislature would have in D1 chosen to take the determination of the public interest away from the local government and place it in the hands of the judiciary?
Well, sir,
when they're only setting aside their own local ordinances?
let me just say I've been with the legislature 63 years, and no, I wasn't 12 when I started. But they can do anything they want to do, but I would submit to you.
Okay, so
the
dichotomy between these two provisions, one sets aside Florida state statutes. So deciding the public interest of setting aside a state statute, they have decided that can't be decided by a local government. That has to be in the hands of the judiciary. But the other framework, they're setting aside their own local ordinances. Where they are setting aside their own local ordinances, do you believe that the legislature, with that language, took the consideration of the public interest out of the hands of the local government when it comes to their own local ordinances and placed it in the hands of the judiciary?
Well, I watched and worked with Burt Harris when he passed his bill. It took him 8 years. Matter of fact, that was passed in tribute to him because he was exiting in his 8th year. And I would submit to you that if you read section 70.0014D1, this is what it says. It says the Burt Harris Act is statutorily authorized when the relief granted would have the effect of a modification, variance, or a special exception to the application of a rule, regulation, or ordinance as would otherwise apply to the subject real property. The relief granted shall protect the public interest served by the regulations at issue and be the appropriate relief necessary to prevent the governmental regulatory effort from inordinately burdening the real property settlement offers.
So this isn't briefed on either side, but let's just take a wild swing at it. Would such a reading that said that a private right of action was created against the local government in determining the public interest of its own local ordinances, would such a reading violate home rule? Would it be unconstitutional under our home rule provisions?
Well, as it says in this, as I said to you before, modification, variance, or special exceptions to the application of a rule, regulation, or ordinance, which would be from the county, as it would otherwise apply to the subject real property. So I would submit to you that this was certainly involving the ordinances, and the comprehensive plan was an ordinance. And comprehensive plan it was all violating those things. But they agreed to it, and they came together and said, we'll do it. Well, since they came together, they should have had that hearing as required under the taken to a judge under the Harris and under the Burt Harris Act. And so I would submit to you that should have been done.
Your opposing counsel just suggested that this did not modify their comprehensive plan at all. This modified some of their local ordinances, but there wasn't actually an effect upon their comprehensive plan.
Well,
and
Your
looking
Honor,
at the list you presented, I think she has a good point.
She's prettier than me, so good reason to listen to her. But I would just submit to you that that's wrong, is that this is the thing that should have gone to that hearing with the judge, because that's what's required under the Burt-Harris Act. And so it did not do that, and so it was not applicable. And if you look at, as far as development code is concerned, or development permit, any building permit, zoning permit, subdivision approval, rezoning, certification, special exception, variance, or any other official action of local government having the effect of permitting the development of land, that is a development permit. And also, as you've seen in our brief, development is considered to be very broad and up to discovery or up to discussion by many people. The development, the carrying out of any building activity or the making of any material change in the use or appearance of a structure or land, or the dividing of land into 3 or more parcels, well, those things occurred. In their, what they call their agreement, it really was a development matter, not a settlement agreement. So I think the settlement agreement was in violation of not
Wow, Mr.
obeying
Jacobs,
to the Burt-Harris Act
if we
also.
read development order that broadly, then what isn't a development order?
I'm sorry if I didn't
If
hear
we
the last-
if we read development order as broadly as you suggest, everything leading up through planning, and it would seem to me that at that point nothing would not be a development order.
Well, sir, that's something you could certainly say, but I also would say to you that this was a settlement agreement. And what it really was, with everything they did, everything they changed, everything they gave, everything they took away, everything they got, and they did it with perpetuity. It's going to last forever. So they did all those things, and that's why it is a development order, not just a settlement agreement. That's my position. And I thank you all for listening to me. I really enjoyed being here. You have a beautiful courthouse. I have never been here before, but I enjoyed being here very much. Thank you all.
Thank you very much, Mr. Jacobs. Okay, we will stand adjourned. Everybody have a safe trip back to your respective homes or wherever y'all are going to.